Hello, and welcome to the arbitration conversation. It's not going to be long, and we will hit our 100th episode. So this is a lot of fun as we get to our final few before we move to a podcast. So what we have today, I'm really excited. We have from Texas A&M School of Law, we have Professor Guillermo Garcia Sanchez. Professor Garcia Sanchez, he has amazing expertise in international oil and gas law, as well as U.S.-Mexico energy relations, comparative law, public international law, international business transactions, and international arbitration. He's currently an associate professor of law, as I said, at Texas A&M, but he's also an affiliate scholar for the Center for U.S. and Mexican Law, University of Houston Law Center, as well as the Center for Energy and Natural Resources at ITAM University, Mexico. He was a law teaching colloquium coordinator at Harvard and a teaching assistant for the John F. Kennedy School of Government, Harvard University. He's got a long history with an amazing education at top schools, and we are very, very pleased to have him with us in the arbitration conversation. So first of all, thank you for taking time.
Thank you, Amy. I'm very excited to be here with you. I follow your conversations constantly, and it's an honor to take part of these conversations.
Well, I have to say, this is great because you're the first person to talk about this topic. So even in 100 episodes, nobody else has covered this topic. So finally, we're getting to it, right? So if you could just tell us a little bit about your work with international oil and gas arbitration.
Absolutely, Amy. So many of you might know that energy law in particular is a very big area of practice for arbitration in general. Just to give you a sense of how many cases are managed a year, just regularly in the exit case law, which is the International Center for Dispute Resolution between states and investors, which is I think the biggest center that deals with energy disputes. There is always roughly between 30 and 40% of the case law that deals with energy disputes. And out of that, 30, 40, there's always around 20, 25 that only deals with oil and gas. Right, so that's hydrocarbons, investments abroad, and many people, are wondering, why is that the case? Well, the first thing that I always talk about in my scholarship and I study is the relationship that emerges when you do international oil and gas deals abroad. It's very different from the relationships that emerge when you do oil and gas deals domestically. And that is particularly clear because in the international arena, 95% of the time, you are dealing with governments because the governments own the resources. Right? And that's a big game changer. In the US, we're used to landowners and dealing with land titles and all those kind of things and mineral rights and who owns the mineral rights. Not only when you deal with the federal government in federal lands, you deal with the governments. But around the globe, it's actually the opposite. It's most of the time you're going to be dealing with governments. And here's one of the important aspects you have to have in mind. The governments of these jurisdictions, like let's say Nigeria, Mexico, Venezuela, Ecuador, between 30 and 60% of the government revenue depends on the extraction of these resources. So that changes the whole dynamics of the relationship, right? Because you are dealing with something that actually is going to have a great impact on the national economy and the government finances and even on governability, right? Because governance in many of these jurisdictions, most of the social programs, most of the investment, the military spending, all comes from funding from the oil and gas industry, right? So all the disputes that emerge out of there are very important. I mean, they have important consequences of how the government is going to behave and engage with investors. And for those that are in arbitration practice, you might remember that some of the oldest cases in international arbitration have to deal with oil and gas, right? So it's the Libya land nationalization processes, the AMCO case, the Iran U.S. claims tribunals. A big chunk of those claims had to do with oil and gas companies doing investments in Iran. The Persian dynasty was still there. So arbitration and energy have always been hand by hand, but we rarely studied arbitration, international arbitration from energy perspective, right? So you have to understand those deals. So most of my scholarship deals with that, the consequences of sending signals to the governments on how they have to interact, how new treaties deal with this type of investments. The new trend now is to have more targeted and tailored international treaties that actually touch on some of the issues that are specific to the energy industry. So you have now the Energy Charter, right? It's a treaty that was drafted particularly for the energy sector, because it not only involves investments there for the extraction of the resources, but also about transit, right? That's a big component. Like, think about also the geopolitics of this particular area, right? Think about Ukraine, think about Russia, the pipelines that are built to bring gas from Russia into the European Union. The European Union basically depends on Russian gas, but you have to build the pipelines to bring it through. So you have to integrate in the treaties what happens with all those investments that are called transit investments, right? Mm-hmm. In the US, we've heard constantly about the Keystone XL pipeline, right? Mm-hmm. That's a big change of policy, big change of government policy to bring tar sands from Canada to be refined down in the south of the United States. That pipeline was, approved and canceled, and approved and canceled. And now the investors are thinking of bringing a claims an investment tribunal using the NAFTA. They have 3 years to do it. So, that's just an introduction of why it is important, how many cases are out there, and the governability issues that involves energy arbitration.
Well, and it sounds like there's going to be political issues that arise in these arbitrations.
Right, and that's why investment arbitration is so important, because it has so many geopolitical aspects, right? So you can think about the pressures that governments receive. So having a neutral forum where you can bring a claim, so these are investment arbitration differs from commercial arbitration in that sense, because it allows companies to bring claims directly against the governments in a neutral forum, right? That is a big game changer. Before investment arbitration actually existed, most of the claims were brought between states, right? So a state would complain with the other state that they were affecting their citizens, and that would even sometimes lead to war. And just just to give you an example, the Mexican nationalization process, right? And the U.S. had to send Marines to take the ports in Tampico and Veracruz during the Mexican Revolution because the investments from oil and gas companies were being affected, right? So the investment system was created to avoid that kind of political pressures, to avoid that kind of political intervention, and then generate a, quote unquote, more neutral forum where investors could actually exercise their rights. Now, as part of my scholarship, where I focus is what are the incentives there, right? The system was created originally to chill down the government policies that would affect government actions that were affecting the original deals that were stricken by the companies with the states. But in practice, what we see nowadays is that most of the investment tribunals have focused their remedies on monetary compensation. They haven't ordered performance. They haven't ordered other types of remedies that are more equitable. They focus primarily on damages compensation. So this ends up sending a very mixed signal to the governments, because if they decide to change their policies and they know that they're going to face an arbitration system, they're always going to put down the numbers and say, well, if we end up going to arbitration, how much do we have to pay the companies? Well, maybe it's going to be, let's say 10 million. Well, how much is the deal? How much the renegotiation of the contract is going to allow us to keep more royalties, to increase the royalties or the government take? And how much are we going to be getting? Well, if this well, let's say working about a particular field, this well is supposed to produce, 2 or 3 billion barrels in the next 20 years. Well, it's worth it, right? We can actually use the oil that we're going to be getting out of the forced renegotiation of the contract and pay the companies 10 years down the road.
Well, right? Yeah, I mean, the piece that's really interesting in your scholarship and as you're discussing is how arbitration really becomes a tool to initiate negotiation, which leads me to wonder, how often do they sort of show up, let's say, for the arbitration, the various parties, the state and the investors, and they negotiate perhaps a settlement. Does that happen very often, or do they actually go to award?
Absolutely. So I always teach my students in class, when you see an arbitration process starting, right? Somebody files an arbitration claim, especially in the oil and gas business or an energy business. We can talk about renewables, because this is not only for oil and gas. We've seen now renewables arbitration cases. But when you see an arbitration case, it's not the end of the game. It's just part of a broader negotiation process, right? Most of the companies and the law firms that are involved in this kind of cases, they have parallel negotiations, right? So they're trying to reach a deal with the governments and how much they have to compensate. Maybe they're thinking in the long run. Again, many of these companies know that the governments require their investments, right? So maybe right now they're not going through a good process or a good relationship with a particular government, but they know that government is going to be over in a couple of years, right? They're going to change, or something is going to happen, or even if the same government stays, the prices of oil are going to go down, they're going to require more capital, or maybe they discover new fields and they don't have the expertise, the state-owned company doesn't have the expertise to develop them, so they're going to require the international oil and gas company to come back. So you want to keep a good relationship, and you're trying to play a long run game here, right? So it's a long-term game. And so many of the companies engage in a conversation, they go into a negotiation process. So just to give you a concrete example that it's really exemplifies this. Venezuela. We've heard about Venezuela. Everybody knows the story about Hugo Chavez, the nationalization, the anti-American narrative, right? So Hugo Chavez, out of the 38 contracts that were adopted in the 1990s when Venezuela opened the energy sector to international companies, 38 deals were signed. When Chavez came along and they forced the renegotiation of those contracts, and it was, kind of a creeping expropriation, if you want to call it. They forced the renegotiation. Out of those 38, 36 companies stayed. They reached a deal. Some of them started arbitration, then they backtracked. They reached a deal. They stayed. They were able to find out a way of still making some money. Only 2 ended up going into arbitration. That's the famous ExxonMobil, ConocoPhillips cases that are, even still going on. And if you take those, that small universe of cases, Venezuela still hasn't paid the awards to ConocoPhillips and ExxonMobil, right? They're still being litigated in the U.S. courts, even though the exit proceeding is over. There are still a bunch of issues. We had a change of government, so it didn't really cost anything to Hugo Chavez at that point because they didn't have to compensate them, right? They reached a different kind of deal with the companies. Now, I always show the other side of the equation is the companies might stay, right? But they're not going to be investing with the same eagerness as before. And that's going to have an impact on the energy sector because the fields are not going to be developed with the same efficiency because the companies are not going to be there in the thinking, I'm going to get the best deal out of this. They're just going to invest the minimum, try to recover as much as they can. And then they're probably going to look for another market down the road. Unless, there's a change of government and then a new opening happening and then that happens and then, renegotiation. So again, arbitration is never the end game. It's just part of the game, right? And negotiation has happened at the same time. Sometimes even mediation is happening at the same time. So it's not, just a one shot.
Right. No, it is really interesting, and it sort of plays in with arbitration as just being one piece of a larger sort of problem-solving perspective for all of these different deals. And same is true, of course, in oil and gas, which leads one to wonder, would there be a better structure, a better way that would maybe be more efficient, more transparent, perhaps, than the current system?
Right. Well, this goes in line with some of the pushes that are out there for reforming the system, right? Since you are dealing with government contracts, you are dealing with government policies. In many cases, the arbitrators are interpreting domestic constitutions, right? So many of these constitutions have long chapters about natural resources, the role of state-owned companies, monopolies. So all of these things are part of the conversation that the arbitrators are having with the parties. So there's a big push saying, let's have more transparent proceedings, right? If we're going to allow arbitrators to interpret constitutional law, public policy, we should know what is happening, right? Because this ultimately involves government finances, it involves governability, it involves a lot of issues. So we should allow more transparency on the system. We should have more, clear rules about who's going to be an arbitrator to avoid a lot of conflict of interest. This is something that's been touched constantly on your conversation, the podcast. There's lack of diversity in many of these investment arbitration cases. Sometimes the arbitrator is also former counsel for one of the companies, or works in a law firm that deals also as is litigating some of the cases. So there are a lot of things there that need to be reformed and amended in order for the system to be a little bit more transparent and to have more reliability on the system. Some countries have decided to step away from the system. Ecuador left the exit convention for a while. Now they're in the process of rejoining. Some countries that were hesitant of joining, like Mexico, now they ratified it when they opened the energy sector. So you see back and forth different attitudes on whether they should be part of the system or not. But I think arbitration is such an traditional system to resolving disputes in the energy sector that is here to stay. We might be doing some changes here and there, but I think we haven't come up with a system that's going to replace the way the arbitration, or the role that arbitration plays in oil and gas and energy.
Right. But some of these pieces, I definitely think, as you mentioned, with transparency, diversity, fairness, anti-corruption policies are all things that could at least help, right, with the system. Absolutely.
Yes, absolutely. And sometimes, that's the other part also that tell my scholarship. Sometimes the narrative that comes from the governments, it's more for a political, it's for a domestic audience, right? Arbitration, international arbitration serves also as a scarecrow or the enemy. It's always easy to come for the government to say, wow, these arbitrators that are imposing these sanctions on us. It's not us, right? It's not they might even end up paying anyway, but they still want to blame someone else outside of the state, right? And that happens constantly in international litigation. I think it's not only unique for the oil and gas sector, but even you see it on maritime delimitation, which is another part of my scholarship. Maritime delimitation or territorial delimitation. It's better for the president of Chile to blame the ICJ for where the line is going than say, oh, I'm the one who negotiated to give 20% of our territory to Peru.
Right.
Nobody wants to be that guy, right?
Right. Absolutely.
And it's the same with the government. Sometimes what you find when you talk to government negotiators and litigants, they are hesitant to be the ones who reach a deal or sign a compensation agreement because they don't want to be the ones being blamed. It's easier to say, well, it's the arbitrator. How did they come up with that number? It was the experts, blah, 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 and we disagree, but that's the arbitrator. And that's, we can't appeal that. As opposed to, why did you end up giving them 10 as opposed to only 8? Well, that was the agreement that were you receiving some money under the table or not? So, anti-corruption, and there's a lot of anti-corruption statutes. So a lot of bureaucrats are saying, I'd rather just fight this to the end, blame the arbitrators, and just move on, right?
Yeah.
So I always tell them, the big question when you see bad narrative against the investment system, in order to realize if it's true or false, just see whether they actually pay or not. Because they might be saying a lot of blah, blah, blah. But if they pay, then that's a good player. They're still playing the game. They are complying with the award. So, you shouldn't go thinking that they hate the system. They're just blaming the system because it helps them politically.
Yeah, absolutely. Well, these are all really great points. Thank you so much. Very excellent points, and your scholarship is really, really spot on. And everybody, please make sure to look out for the articles of Professor Garcia Sanchez. He's written some wonderful work. I'm going to keep watching your scholarship, and I'm really thankful that you took time today. Thank you very much.
Thank you so much, Amy. And I look forward to the 100th episode and to the podcast.
Absolutely. Take good care.
You too.